tribunal, I was almost using another expression which is common in the United States, but I will refrain it in light of other discussions you have in this country. But this is a tribunal that has read the files extensively. For weeks we have been studying this. So don't think that we are a cold bench. We have read it, and it is in that perspective we would like the parties to invite them really to only to focus on the major issues in the opening statements. And that also would then translate into being economical with the time allotted to you, so that we can advance with the case with expediency as required. Length, may I remind you, the length is maximum 3.5 hours, is 210 minutes. Mr. Colbert, Professor Colbert, I think you're the first one to start. Your time starts now.
Thank you very much. We have prepared opening bundles for the tribunal and of course for the other side. So I'll just wait for them to be distributed.
Sorry, can we just make a note for the record? It's good custom that to give bundles and materials to the other side first and only then to the tribunal. And I think we should abide by this rule in this arbitration.
May I start, Mr. Chairman?
You may. Please
Thank
proceed.
you. Good morning, Mr. Chairman, members of the tribunal. You see the structure of our opening statement on the first page of the bundle. So I will start out with an introduction and overview of our case, and then Dr. Happ will present the claimant companies. He will talk about the atomkonsens, the investments made after the atomkonsens, the lifetime extension, and talk about the Krümmel plant. Then Mr. Rangwall will continue and talk about the Fukushima accident and the events leading up to the 13th Amendment, and briefly address the consequences that the 13th Amendment had on the claimants. Then Mr. Anderson will address liability and the legal aspects of the case, and I will come back towards the end and say a few words about quantum. And that concludes our presentation. This dispute arises out of Germany's decision following the Fukushima accident on the 11th of March 2011 to shut down claimants' nuclear power plants, to revoke rights granted 6 months before, which destroyed the value of claimants' other investments by distorting the market. We have heard and seen quite a lot from the respondent side what this case is allegedly all about. It is appropriate, we think, to start out this hearing by pointing out what the case is not about. I have 3 points. First, this case is not about the use of nuclear energy. We are not taking any view in this case as to whether nuclear energy is to be preferred over any other energy source, or vice versa. Preference of a particular energy source does not form part of international law. This case could have related to investments in different energy sectors or a completely different sector altogether. The subject matter of the dispute does not affect the applicable rules and principles that you as members of this tribunal will have to apply. We are faced with a situation where Germany took certain measures in 2011 that targeted our clients' investments, which happened to be in the energy sector. And this whole event, if I may say so, has become, as you are well aware, of a hotly debated topic. In fact, in Germany it has become a political football, particularly in relation to the general debate about TTIP, CETA, and investment arbitration. That is all politics. In this conference room, however, we are dealing with international law and the ECT, the Energy Charter Treaty. Germany has talked a lot about perception, but public perception is not a valid defense for Germany in this case. My second point is that this case is not about the safety of nuclear energy. The German Atomic Energy Act allows the state to shut down nuclear plants which pose a risk to the population. Yet no such risks exist. Germany has admitted in this arbitration that its decision to accelerate the phase-out was not based on concerns over safety of the nuclear power plants, but merely on an alleged changed perception of the general risk that nuclear energy poses to the German population. This perception, however, as I said, is not a proper justification under German law or international law for the state to shut down perfectly safe nuclear power plants. Germany has admitted that Claimant's plants were safe. Germany has also admitted that it would have to amend its law to find a proper basis to shut down Claimant's plants without paying compensation. We get this from Claimant's Exhibit C0111, which is a memorandum from the Ministry of Justice in Schleswig-Holstein. This is but one document where this is confirmed. C0111, pages 4 to 5. My third point is this. The dispute does not concern Germany's right as such to phase out nuclear energy. Germany has taken its decision. We do not ask you to reverse that decision. We do not question Germany's right to regulate. We accept that. But Germany must be held responsible for the consequences of its decisions. Germany has exercised its authority as a sovereign by signing the ECT. The ECT is a limitation on the sovereignty of Germany, as is any treaty, as you well know, based on the Pacta Sunt Servanda principle and indeed a cornerstone of international law. Germany has accepted this limitation that is imposed by the ECT when signing and ratifying the ECT. It is still a member of the ECT. German companies actually rely on the ECT in other investment disputes. Rather, this dispute concerns the manner in which Germany has chosen to implement its phase-out decision and its failure to properly protect claimants' investments. In particular, it concerns Germany's failure to pay any compensation at all. The bottom line legal question in this case is this, we submit. Does a mere alleged change of perception of risk entitle a state to shut down industrial installations which comply with existing laws and regulations, to change rules and regulations on which investors had relied to invest hundreds of millions of euro, to deprive their assets of any value, and to do all of this without compensation? We say the answer is clearly no. Germany seems in fact to be of the same view. It has spent most of its energy in this case arguing that claimants have not suffered any loss at all and would even be better off with the shutdown, or better off than without the shutdown, so that no compensation is due. The subtext being, of course, that if claimants have indeed suffered a loss, claimants are entitled to compensation. We will show in the coming 2 weeks in this hearing that Germany is wrong in all respects, on jurisdiction, on liability, and on quantum. With that introduction, I then move on to a brief overview of the case. I will focus on the facts, the law, and a bit on quantum. And my colleagues, Dr. Hupp and Mr. Rangwall, will focus more on facts in detail, and Mr. Anderson will, as I said before, focus on the applicable legal rules. So let me start with an overview, a brief overview of the facts. Claimants own and control investments in 3 nuclear power plants in Germany. They control and operate the nuclear power plants in Brunsbüttel, that's the KKB plant, and in Krümmel, that's the KKK plant. In addition, claimants own a minority shareholding in a third nuclear power plant, Bruckdorf, which we call the KBR plant. The operation of nuclear power plants in Germany is regulated by, as you know by now, the Atomic Energy Act of 1959. For several decades, the licenses for operating a nuclear power plant were not allowed to contain time limits to operate the plants. In 2001, the so-called atomkonsens was concluded, and you have that as Claimant's Exhibit C0016. This agreement, the atomkonsens, provided for a structured phase-out of nuclear power and was concluded between Germany's nuclear power plant operators and the government, the German government at the time. Under the atomkonsens, the nuclear power plant operators agreed to a limitation of the electricity production and thereby to a limitation of the operating lifetime of their power plants. The quid pro quo was that each nuclear power plant was allocated specific volumes of electricity that it was allowed to produce before it would have to stop production. These are the so-called electricity production volumes, and those created based on the atomkonsens we refer to as the old volumes, OEPV. The electricity production volumes could be sold to other nuclear power plants. The amount of electricity production volumes was calculated in the atomkonsens in a way so as to ensure that the nuclear power plants operators could make an appropriate profit. This is a quote from the 2002 draft amendment which followed of the act which followed the atomkonsens. This you find in Exhibit C0015, page 16. Further, in the atomkonsens, the German government specifically undertook to ensure undisturbed operation of the nuclear power plants and to abstain from implementing any discriminating taxes. In 2002, the atomkonsens was incorporated into the Atomic Energy Act. Claimants relied on the assurances and promises given in the atomkonsens and invested considerable amounts of money in their nuclear power plants. At the same time, they hoped and made certain plans that the future government might extend the lifetime of their plants. And indeed, after the elections in 2009, a new government under Federal Chancellor Dr. Angela Merkel was formed. The new government adopted an energy policy intended to be valid until 2050. As part of the Energy Policy 2050, and in line with the hopes and expectations of the claimants, the lifetime of German nuclear power plants was to be extended to bridge the transition to renewable energy resources, or sources, I should say. This extension was achieved by granting the nuclear power plants operators additional electricity production volumes. These are the new volumes which we call NEPV. This extension of the lifetime of German nuclear power plants became known as the lifetime extension. This is also the term that we've used in our briefs, both sides. All of claimants' plants received lifetime extension. The lifetime extension was based on the Development Fund Agreement, which is Claimant's Exhibit C0017, which had been negotiated between the government and the nuclear power plant operators for months, and which was concluded in November 2010/January 2011. In the Development Fund Agreement, the government confirmed the necessity to regulate the lifetime of the nuclear power plants as an integral element of Energy Policy 2050. The Development Fund Agreement confirmed that the atomkonsens remained valid. The lifetime extension was implemented in December 2010, just 3 months before the Fukushima accident, through the adoption of the 11th Amendment of the Atomic Energy Act. At about the same time, the government enacted a tax on nuclear fuel. The power plant operators from the very beginning opposed this tax. It breached the atomkonsens and was held by the operators to be unconstitutional. They launched multiple claims in Germany, which are still pending, some of them in German courts. In the spring of 2011, Elections in several federal states, Länder, were approaching. The outcome was particularly important for the government's position in Germany's second parliamentary chamber, the Bundesrat, which is composed of Länder representatives. On 11th of March 2011, the Fukushima accident suddenly turned a tragic event into the most important issue on the German political agenda. A few days after the Fukushima accident, on 14th of March 2011, Federal Chancellor Merkel announced that the lifetime extension would be suspended for 3 months, during which an extraordinary review of the safety of all German nuclear power plants would be conducted. The 7 old nuclear power plants were ordered to be temporarily shut down during the safety review. The new nuclear power plants were to be reviewed while operating. The temporary shutdown of the old power plants became known as the moratorium. An old plant, by the way, is one who started operation before 1980, new plants thereafter. Following the Fukushima accident, the German government instructed the Reactor Safety Commission to review the safety of German nuclear power plants. In addition, the government established an ad hoc committee, the so-called Ethics Commission, to review the ethical implications of nuclear power plant operation following the accident. As ultimately concluded by these commissions, nothing objectively changed for nuclear energy in Germany on the 11th of March 2011. Though Fukushima obviously was a tragedy in its own right, the accident had no objective relevance to the assessment of safety for German nuclear power plants. It was well known at the time, and has been confirmed by Germany in this arbitration as well, that the safety standards for Germany's nuclear power plants are and were met. In disregard of the atomkonsens and its previous promises to await the outcome of the reviews of the Reactor Safety Commission and the Ethics Commission, the government proceeded to prepare a draft bill making the moratorium permanent well before the reports were published and rendered. This draft bill would eventually become the 13th Amendment of the Atomic Energy Act, ultimately providing not only for the immediate shutdown of the 7 old plants, but also of the KKK plant, the Krümmel plant, which was a new plant. In addition, the draft bill included a schedule setting out fixed shutdown dates for the remaining new plants, thereby effectively destroying the market for the electricity production volumes. The 13th Amendment was completely unexpected, not only to claimants but to everyone else. After all, only a few months before Fukushima, it had taken measures to increase the production of nuclear produced energy through the lifetime extension. There is not a single document in this case even remotely suggesting that the objective reality changed between the autumn of 2010 and the spring of 2011, when the moratorium and the 13th Amendment was implemented. What made Germany then to react, in fact, entirely differently than the rest of the world? Because Germany did react very differently from the rest of the world. The answer again is perception. Perception seen through the eyes of politicians. The measures taken by Germany, which violated the obligations under the ICSID, were all based on what certain politicians believed to be the public perception of nuclear energy. The measures taken through the moratorium were widely seen as purely political in light of the upcoming Länder elections. Contrary to what the government seemed to have expected, though, the decision to introduce the moratorium did not increase the support for the governing coalition parties. Quite the contrary. Ultimately, the 13th Amendment to the Atomic Energy Act was adopted then and entered into force on the 6th of August 2011. By implementing the 13th Amendment, Germany ignored the findings of the Reactor Safety Commission, which in its report published on the 16th of May 2011 concluded that German nuclear power plants were safe, that the events in Fukushima could not happen in Germany, and that any differentiation between old and new nuclear power plants could not be made for reasons of safety. In its rejoinder, Germany states that the 13th Amendment was the result of, quote, new experience and knowledge gained. This is para 11 in their rejoinder, and of changing circumstances and new technological, scientific and factual insights. This is para 19 in the same submission. None of that is true. There were no facts or insights which had any relevance for German nuclear power plants. Once again, the German government and the German legislature acted on what they believed to be public perception. Claimants are not contending that they expected the applicable safety regulations to remain constant forever. Previous nuclear accidents and technical development had resulted in more stringent safety rules, and this development was one that could have been expected. However, there is a significant difference between reassessments and modifications of safety rules within the already existing framework on the one hand, and an immediate shutdown and revocation of the NEPV on the other. In its rejoinder, Germany points out, this is para 7, that the impact of the Fukushima accident was quite literally felt around the world. Yes, that's true, as far as media attention is concerned. However, whereas all other countries in Europe and globally were participating in fact-finding missions, first to find out the real causes of the problem at Fukushima, or that caused Fukushima, Germany took a politically motivated decision based on alleged public perception, i.e. to permanently shut down claimants' plants and revoking and destroying their production electricity volumes. As a consequence of the 13th Amendment, claimants lost their production licenses for the Krimmel plant and for the Brunsbüttel plant. They were simply withdrawn. All of their NEPV's new production volumes were revoked. Claimants cannot sell the remaining old volumes to other still operating nuclear power plants because there is no market for claimants to sell their old PVs. By immediately shutting down 8 nuclear power plants, 7 old ones and 1 new, and limiting the lifetime of the remaining plants, Germany destroyed the market for old volumes. As I said, it is still allowed to sell them, but there is simply no market. So that is a short overview of the facts. Let me then move on and say a few words about the applicable legal framework in this case. Mr. Anderson, as I said, will go more into the details of the legal aspects. Germany is seeking to rely on German law and the German constitution in this case. Germany's attempt to justify its treatment of claimants by referring to German law, we say, lacks merit. This dispute is governed by international law, public international law, and the ECT, and that's it. It is a well-established principle, as you well know, that Germany, like any state, cannot escape liability for breach of international obligations by referring to its own domestic legal order. In fact, that is a cornerstone of public international law. Germany cannot validly defend itself by saying that it as a sovereign state had the right, and as they would have it, also the obligation to take the measures it took in 2011. It tries to portray, it seems, this case as some form of domestic matter governed by the German constitution and case law coming out from the German Constitutional Court. As I said, as a matter of international law and also based on the ECT, German law is not the applicable law here. And that domestic law is not applicable in these kinds of disputes, as you well know. I mean, this is based on the Vienna Convention and on the ILC Articles of State Responsibility. Rather, as Germany agreed when signing and ratifying the ECT, this case is heard under the Energy Charter Treaty and the applicable rules and principles of international law. There is nothing in the ECT about application of domestic or municipal law. Germany has breached its obligations towards claimant under the ECT in several ways. In particular, Germany has unlawfully, both directly and indirectly, expropriated claimants' investments based on under Article 13 by revoking all of claimants' new production volumes for all plants, by permanently revoking claimants' license to operate the Krümmel plant and the Brunsbüttel plant, and by rendering claimants' rights to old volumes worthless by destroying the market, that is Krümmel and Brunsbüttel. The measures taken by Germany, in fact, took away all future income and left claimants with significant liabilities. In fact, in a situation which is worse than if there had been a expropriation by transfer of risk, because the plant operators are still carrying obligations for decommissioning. Germany has also breached its obligations under the atomkonsens and the Development Fund Agreement, and therefore is in violation of the umbrella clause in Article 10.1 of the ECT. It has also breached its obligations under the Fair and Equitable Treatment Standard by imposing the nuclear fuel tax in 2010 and passing the 13th Amendment, which was in direct contravention of Germany's specific assurances of stability and the need for long-term planning in the nuclear energy sector, which were given in the atomkonsens and the 2002 Amendment of the Act. We have also explained that Germany has acted unreasonably and in a discriminatory manner under the ECT, as well as failed to provide claimants with the most constant protection and security. And Mr. Anderson will develop that further. Finally, then, a few words about quantum. Germany's breaches of the ECT have caused considerable damage to claimants. To quantify the damage claimants have suffered, Mr. Kaczmarek has first calculated the value of the investments without the 13th Amendment and the nuclear fuel tax as of 14th of March. That is the so-called but-for value. The 14th of March was the date, evaluation date, the date immediately before the expropriations took place. Mr. Kaczmarek has then calculated the value of claimants' investments taking into account the 13th Amendment, i.e. the actual value, so the but-for value and the actual value. And the difference between the two, of course, makes out our damages. To do this, he has to calculate the fair market value of the investments. He has used the discounted cash flow method. Mr. Kaczmarek has calculated separate damages for each of claimants' nuclear power plants. Moreover, he has provided alternative calculations in the event that the tribunal should find that it does not have jurisdiction over certain claimants. The total amount of damages claimed is about 5.7 billion. I will come back to describe our prayers for relief when I deal with quantum later on. That amount includes pre-award interest calculated up to today. In this connection, it is worthwhile mentioning that when the Swedish state decided to close down the Barsebäck plant in Sweden, that's in the south of Sweden, the Swedish state actually paid compensation to E.ON as an operator. However, Germany has been far less accommodating, refusing to pay a single cent to claimants after closing down the nuclear power plants. Germany's suggestion that claimants in fact have benefited from the 13th Amendment, quite frankly, makes you want to reach for the smelling salts. In order to arrive at this conclusion, Germany has instructed their experts to make a number of incorrect assumptions and to make an ex post analysis of claimant's claim, all of which is wrong. Apart from the fact that it would be wrong under the circumstances to apply the ex post method as such, it is not possible to make a reliable ex post calculation of the damages suffered by claimants. This has been explained in detail by Mr. Kaczmarek. In fact, the expert evidence relied on by Germany in support of its assertion that claimants have not suffered any loss includes a number of errors and mistakes which will become apparent during the course of this hearing, we say. So before I hand over to Dr. Happ, let me say this. The essence of Germany's case in this arbitration is that the alleged public perception against nuclear energy in Germany somehow justifies its decision to accelerate the shutdown of nuclear energy without having to pay any compensation to claimants. There is no principle of public perception in international law, nor is there any such principle under the Energy Charter Treaty. There is no right, no standard, no exception, no common practice relating to public perception. The Energy Charter Treaty is a set of rules to be applied in a neutral manner to the facts specific to the individual case. Knowing this, Germany attempts to cast doubt as to the safety and reliability of claimants' nuclear power plants and insinuates that there would be a danger to its citizens in light of Fukushima, quote unquote, if claimants' plants were not shut down. Despite Germany's attempts, it is clear that this case is not about safety, as I said before. As Germany itself has admitted in this arbitration and in the pending constitutional court proceedings, claimants' plants met the requirements of up-to-date safety regulations in Germany. What Germany is trying to do in this arbitration is to exploit the Fukushima disaster to create a narrative that would excuse its wrongdoing. However, this cannot be done under the ICSID or under any other principle of international law, nor can it be used to cloak otherwise wrongful acts under the guise of sovereign rights. You can put perfume on it, you can put any other cosmetics you like on it, but the bottom line is the bottom line. And the bottom line here is that international law and the ICSID govern this dispute. So thereby I hand over to Dr. Happ.
Thank you, Professor Robert. Mr. President, members of the Tribunal, as Professor Robert has explained to you, I will set out in a bit more detail the background of the dispute, in particular the relevant factual development from the first investment acquired until the accident of Fukushima. Given that you, Mr. President, has pointed out that this is not a cold bench, I'll try to avoid as many repetitions as possible. Let me start with the claimants. You see on the screen the structure of the claimants. At the top you see claimant number 1, which is Vattenfall AB, a Swedish stock corporation. It is one of Europe's largest energy providers with activities also in other European countries than Sweden or Germany. Vattenfall AB owns 100% of what is now the second claimant, Vattenfall GmbH. As you know, members of the Tribunal, these proceedings were initially started by Vattenfall Europe AG as claimant number 2, a stock corporation under German law. Vattenfall Europe AG was the same legal entity and direct successor of HEW, the original holder of the operating permits for the power plants relevant in this arbitration. After registration of the case, Vattenfall Europe was merged into Vattenfall GmbH, and in parallel an existing domination agreement was terminated. Now Germany argues that by terminating this domination agreement, Vattenfall AB has lost control of its German subsidiaries. We have explained in our memorial why this is incorrect, and you will also hear next Monday Professor Christoph Schroyer on the issue of control, but we deem it apposite to shed some lights on the German law aspects of this contention, which we have also set out in briefs, because this contention is, and what sometimes one needs to call a spade, just nonsense. Vattenfall Europe AG was a stock corporation. Under German law, the shareholder of a stock corporation cannot give instructions to the management. You need a domination agreement for that, which subjugates one company under the will of another company. That is completely different with a corporation with limited liability, such as Vattenfall GmbH. The shareholder of a corporation with limited liability anytime can make a shareholder resolution which is binding for the management of that corporation. Thus, Vattenfall AB can directly give instructions to Vattenfall GmbH because it's a 100% shareholder. You will find below Vattenfall GmbH claimant number 3, which is Vattenfall Nuclear. Vattenfall Nuclear was spun out of HEW in 2022 during the reorganization of the German subsidiaries which Vattenfall AB had acquired. It too is a limited liability company, and it too is 100% owned by Vattenfall GmbH. Thus, Vattenfall GmbH can give direct instructions to the managing director of Vattenfall Nuclear. Vattenfall Nuclear now has a double function. On the one hand, it holds the shares in the power plant companies for the 3 power plants in this arbitration. 50% for Krümmel, 66.7% for Brunsbüttel, and a minority share of 20% for Brockdorf. On the other hand, it is by virtue of the shareholder agreements the managing director of the power plant companies for Krümmel and Brunsbüttel. That means that there's a direct line where direct control, where instructions can be given from Vattenfall AB to Vattenfall GmbH, which in turn can give instructions to Vattenfall Nuclear, which under the shareholding agreement happens to be the managing director of the power plant companies. And as we've also set out in our briefs, Vattenfall Group in 2011 had set up a system of powers of attorneys with which very easily these shareholder powers could be delegated to individual persons to exercise control. But you will hear in more detail on this and on the international law aspects which are relevant here, Professor Scheuer, next week.
Before we continue, could you please stay on this slide? Could you describe for us what is in your submission, in the claimant submission, the investment? You have just described the investor.
Certainly. Mr. President, there are multiple investments, but finally and ultimately what we are discussing here are the 20% minority share in Kernkraftwerk Brockdorf GmbH, and then we say that since Vattenfall AB indirectly controls the power plant companies, that the power plant companies Krümmel and Brunsbüttel are also the investments. You can, when you take the perspective of Vattenfall AB, you can also go back and take the perspective of that Vattenfall Nuclear also is an investment. But it's at the same time also a claimant, since it's a claimant in its own right.
To be clear, the investments are, I don't know whether it works, yes, it works. The 3 companies you see at the bottom here,
Yes.
plus the one, the Kernkraft Brockdorf.
The investment would, when you look at the bottom line, does this work? No.
Yeah,
There should be a laser pointer, but it doesn't work. You'll have an investment of 20% in Kernkraftwerk Brockdorf, and there the investment would be the share of 20%, and you'll have a share of 67% in Kernkraftwerk Brunsbüttel, and since we say that Vattenfall AB indirectly controls Brunsbüttel, Brunsbüttel is the investment of the company.
I asked you this question because I looked to the chart of Mr. Kasmerik's first report at paragraph 35, and there you see in yellow what he states as his assumption for what is the investment of your client.
Okay. Can I take a brief look at it and then? Okay.
It's figure 1. If it requires too much time, maybe you can address that later.
will park that issue and come back to it.
Could you also try to speak in the microphone?
Perhaps I'll take that one. Is that now better? Okay, excellent, thank you. I would now like to briefly explain to you about the political and legal framework in which claimants acquired and Claimant and Vattenfall AB acquired the shares in the power plants. That is relevant because it forms the background of this dispute, and we think it's necessary to understand the framework in order to assess why this dispute had arisen. As Professor Robert already has mentioned, and as you certainly know, the operation of nuclear power plants in Germany is governed by the Atomic Energy Act of 1959. It has certain essential features which remained unchanged since 1959, which remained unchanged since the time Vattenfall acquired the shares in HEW and the power plant companies, and which are still valid today. Those 5 features which we deem to be relevant for this case is firstly that operating licenses are unlimited in time. There is no temporal time limit in there, it's forbidden by law. Second, there are only limited possibilities to withdraw licenses. These are regulated in Section 17 of the Atomic Energy Act. Thirdly, and I'm speaking of a withdrawal of a license by administrative act, that the supervisory authority decides to revoke a license. Thirdly, the general rule is that if the supervisory authority revokes a license, compensation has to be paid, except also in rather some more complicated exceptions which are regulated, for example, if it has been the fault of the operator. Fourthly, there's an extensive supervision by the authority and its experts. That is relevant in this case, members of the tribunal. You all heard in the pleadings and the submissions about the TÜV, the Technical Review Association which examines the power plants. The TÜV is the expert of the authority. The authority instructs the TÜV. The authority gets the reports by the TÜV. All that claimants have to do with it, they have to pay. And a respondent a couple of times has complained that claimants had not provided full documents which the TÜV and the authority has in its possession. We find this highly misleading. It's their documents. The documents are in the possession of the authority, and the authority, as I will explain in a minute, is under the control of the federal government due to the principle of federal commission. It is in their realm. They have all the documents. The authority knows the power plant pretty well. It has all the expert reports. And lastly, Section 19 of the Atomic Energy Act regulates that the power plant can be shut down temporarily in cases for dangerous life, health, or property. That is also relevant. We will discuss it in the context of the reliability and the question whether reliability is a reason for stopping the restart of a power plant. And you will hear also our experts on that, in particular Professor Arndt. Now, I've just mentioned that the supervisory authorities execute the Atomic Energy Act by means of federal commission. That means that the Federal Ministry of the Environment supervises the proceedings in the sense they can at any time, if they wish, step in and give binding instructions to the land authorities how to deal with a certain case. That has happened in the past, and that has led to conflicts between Bund and land authorities that in particular happened after the accident of Chernobyl in the 80s. You see on the screen a short table which very briefly and very roughly summarizes the different attitudes of Bund and Länder governments in relation to nuclear power. When the act was enacted in 1959, nuclear power was basically undisputed in Bund and Länder, and it bears noting perhaps that the power plants, nearly all nuclear power plants, were built by state-owned companies. HEW was state-owned, RWE was state-owned, E.ON's predecessor was also state-owned. The state furthered and sponsored nuclear energy. This had only changed after the accident of Fukushima in the 1980s, but only on the level of the individual Länder, where you had governments formed by Social Democrats and Greens, which were opposed to nuclear power, and then the federal government, which at that time was nuclear friendly, had to give instructions, Weisungen under Federal Commission, to the Länder authorities, which led to cases even before the Constitutional Court. This again changed in 1998, and we deal with that in a minute on the subject of the atomkonsens. This forms the background to understand the atomkonsens, when Chancellor Schröder became Federal Chancellor and wanted to phase out of nuclear power, while you had Länder governments which partially were against nuclear and partially for nuclear energy. This is the background, members of the tribunal, before the atomkonsens was negotiated and concluded. The background is that the operators had a very clear interest in an undisturbed operation. Then what has happened and why they had this interest is very simple. Länder authorities, some Länder authorities, tended to interpret the Atomic Energy Act as widely as possible with a view to make the operation of nuclear power plants as costly and as expensive as possible. That is what we call the phase-out implemented orientation of the law. And we know that respondent denies that such things have happened, but we ask you to take a look at the preamble already of the atomkonsens, which very clearly recites what the parties want. The federal government and the supply companies agreed to put time limits on the future use, and now you see what they get in return. Undisturbed operation of nuclear power plants and their disposal are to be guaranteed. One really needs to read this closely. In return for waiving a part of the rights which they have under law, the operators received from the government a guarantee that in future the operation would remain undisturbed. This has been bitterly complained on by Dr. Angela Merkel, at that time leader of the opposition, when the atomkonsens was discussed in Parliament. And you see here on the screen, that is Exhibit CO65, a quote from what she said. And she says, "Business had no other choice but to consent to this agreement." She says, "I believe the type of social policy that this agreement enabled and which was attempted to be practiced over decades, I believe to be exceptionally worthy of criticism from a rule of law perspective. Namely," that was too fast, "namely to attempt to override laws which were adopted with majorities at the time through the enforcement of laws aligned with achieving a phase-out." The atomkonsens, as we have explained, was negotiated over a period of nearly 12 months. It was initialed in June 2000 and signed a year later. And you see on the screen a copy of the signature page in German. And you see on the left-hand side that it was signed by the 4 CEOs of the nuclear power plant operators, the holding companies. On the right, you see the signatures of Federal Chancellor Schröder, of the Minister for the Environment, and of the Minister for Economy. It is noteworthy that HEU signed this, although it had not been invited to the negotiations. This atomkonsens had been negotiated without HEW, and as I'll explain in a minute, they had seriously to consider whether to sign it or not, but then said that they would sign it because they relied on promises. I'm coming to that in a minute. The essential idea behind the atomkonsens is that you do not put temporal time limits on the operation of power plants, but that electricity production volumes were assigned, measured in terawatt hours, that are million megawatt hours, and that once these electricity production volumes were exhausted, the right to operate the nuclear power plant would be exhausted. Second, the electricity production volumes could be used up either in the plant for which they were initially granted, or they could be transferred. And you may find it interesting that already the atomkonsens speaks of the electricity volumes as production rights. And it is our submission that there are production rights about which the operators can freely dispose. And you'll hear more about this by my colleagues and also by our experts. They can be transferred, in particular they can be sold, and we think, why does it work? And the effect is quite simple. If they are sold, the selling nuclear power plant has less volumes, its operating time is reduced, and the other company gets an increased operating time. The amount of electricity production volumes which was allocated to the individual power plants was calculated in a 4-step process. The first step was that one looked at the average production of the best 5 years from 1990 to 1991. And the result was a certain amount of terawatt hours. Usually for Kreml it would have been something around 10, other power plants with the same capacity, something like 10 terawatt hours. Then this was multiplied by 5.5% for a variety of reasons, possible future increases in capacity, a better operation of the plant within grid structures. But basically, the best average was increased by a further 5.5%. That what you then had were the so-called reference production volumes, what the parties thought could be perhaps produced in a year. And that was multiplied by 32 years. And then in the 4th step, you deduct what had been produced already until 2000. And then you have the amount of electricity volumes which are allocated to a nuclear power plant. For Kreml, for example, it was approximately 158 terawatt hours. Do you have a question, Mr. President? Because, okay. Now,
if you go back 2 slides,
yes.
you say that these EPVs can be sold from one power plant to the other.
They can be sold from one power plant to the other under the Atomic Energy Act as enacted only from older power plants to newer power plants.
So that was completely, because if you read the section 4, it's all from old to new you can do, but not the others all the way around, unless you get an authorization.
The atomkonsens didn't pronounce it that way, but under the law it can only be freely sold from an older to a newer one. If you want to transfer it from a newer one to an older one, you need the consent of the Federal Ministry for the Environment, which I think was never given. Members of the tribunal, Germany did not simply sign a document with empty phrases. It gave very clear promises under the Atomkonsens, both as regards the regulatory framework and the economic framework for operating nuclear power plants. You see here one excerpt from the Atomkonsens that is on page 6, section 3, and it says, during the residual lifespans. And with this term, the Atomkonsens refers to the amount of time in which the electricity volumes will be used up. The high safety standard required by law and statute will continue to be assured. The federal government will take no step to change the safety standard and its underlying safety philosophy. And now this doesn't work properly. And subject, now it's important, subject to compliance with the requirements in the nuclear law, the federal government will ensure the undisturbed operation of the installations. We consider this to be particularly interesting and noteworthy because Germany has admitted in its rejoinder that Kreml met the requirements for being safe under German nuclear law. And that's one of the reasons on which my colleagues will deal, why we directly think that this provision, this promise given here, has been breached. The second promise given is in relation to the economic framework conditions. The federal government will take no steps that will discriminate against the use of nuclear energy by unilateral measures. And then the consent says the same shall apply to tax law. Now, these are not just empty promises. Germany has twice publicly confirmed that these promises are to give planning security to the operators and that there are guarantees. You see on the screen 2 excerpts. One document is the discussion in Parliament, and you see highlighted a quote from Chancellor Dr. Schröder, where he says the agreement reached with their participation gives them, the operators, the needed planning security. And on the right column you see an excerpt from the explanatory part of the bill which implements the Atomkonsens, and it says, under the agreement of June 14, 2000, undisturbed operation of nuclear power plants and their disposal are to be guaranteed. The atomkonsens is to give planning security and guarantees. And HEW relied on that. As I have explained to you a couple of minutes ago, HEW had not been invited to the negotiations. It had not had the chance to influence the content of the atomkonsens, and it had been disadvantaged by the calculation mechanism because its power plants had been offline longer than other power plants in the 90s, for example, for renovations of piping. Therefore, its best 5 years in the 90s were less than what other operators had in comparison. And you see on the screen now a quote from HEW's then CEO, Dr. Manfred Timm, at the balance sheet press conference shortly before the atomkonsens was signed. And there he says why HEW nevertheless decided to sign the atomkonsens. The federal government is obliged to ensure the plant's undisturbed obligation and disposal. This is the deciding factor for us. And then he continues and says, we have agreed to the proposal because the advantages that we see in the government's firm assurance of undisturbed operation outweigh the disadvantages. It subsequently, then was also renamed as Vattenfall, relied on the atomkonsens. We have put into the record 2 witness statements, one by Mr. Neugebauer and one by Professor Tomauske, whom you will also hear. And Mr. Neugebauer testified that between 2002 and 2011, nearly 1 billion euro were spent on Krümmel and Brunsbüttel alone, and that 540 million euro of this sum were so-called CAN investments, investments which were not required by the authorities, which were not mandatory under law, but which Vattenfall invested. And Professor Tomauske confirms in his witness statement that these sums were invested in the reliance on the electricity production volumes. He says, the investments that were made during my time at Vattenfall Nuclear were made in reliance on the volumes. And you see very clearly after the highlighted sentence, he says, no enterprise would invest such sums unless they were confident that these investments would be paid back during the operational life of the plant. Members of the tribunal, you no doubt have noted that one of the bitterly disputed issues between respondent and claimants is whether the atomkonsens is binding or not. You see on the screen a quote from Germany's rejoinder, counter-memorial, sorry. There Germany contends that its constitutional court had confirmed that the atomkonsens was non-binding. And you see the quote on which they rely, which is, that's already noteworthy, half a sentence. We think this is, to put it frank, extremely misleading by Germany, and we feel obliged to set the record already now straight and to show you what the Constitutional Court really said. That is the highlighted section, and that is what the court really said. The court speaks about says the content of Appendix 2 of the atomkonsens, which relates to the nuclear power plant Biblis, is within the scope of competence of the federal government. Its significance is low, and that refers to Appendix 2. It is characteristic of commonly found political statements on which no responsible person of sound mind would hang his head. And we have to say we agree with the Constitutional Court on this, because if you look at what Appendix 2 says, it is not a contract. Appendix 2 is a statement made by the Federal Ministry of the Environment to one of HEW's competitors, to RWE. And just look at the language. It says the ministry, the Federal Ministry of Environment, reaffirms its opinion. It is examining issues. It will determine measures required to accelerate. And it will render a decision, and it will adjust subsequent requirements, and it will promptly initiate the necessary talk. This is soft law at its best. It is poles apart, no, it's galaxies apart from the clear promises given in the atomkonsens, which according to the government itself were to give planning security and guarantees. Now, unless you have any questions on that point, I will continue with the point of lifetime extension. Judge Bauer?
Well, the atomkonsens in German is denominated Vereinbarung. Are you in dispute between the parties as to the proper translation of the word Vereinbarung?
To which I may add the other word Vertrag.
Sorry?
To which I may add the other word in German, Vertrag. And that's the distinction I understand that is being made by the respondent.
The distinction has been made by respondent. You will hear on this our expert, Professor Kischel, who will argue and interpret that there is no difference, meaning that a Vereinbarung can also be a binding agreement.
Right. And there's what significance, if any, is there in the fact that the atomkonsens was not signed by, as I understand it, any of your clients?
Well, the atomkonsens, Judge Bauer, and that I thank you for the question because it gives me the possibility to correct the misunderstanding. It was signed by HEW. Let me briefly go back.
On the signature page I'm looking at.
Wait, this goes not as fast as it should. That is where's Hy-Vee? That's what links, yeah, the lower signature at the bottom of the left column. But the point is they were initially not invited. For them it was a take it or leave it deal.
Ah, HEW.
Yeah. And HEW at that time, well, I need to look at it again, but I think already more than 50% were owned by Vattenfall, and Vattenfall was also in the supervisory board and had to give its consent to signing the atomkonsens. And as I said at the beginning, what was Vattenfall Europe AG, that was HEW. So essentially, the claimant sits here.
Okay.
HEW sits here.
I got it. That's it.
Okay, thank you. Then I would now continue with the issue of the lifetime extension. Right. Okay. The lifetime extension, members of the tribunal, has been politically planned for years. It had been negotiated for months, and it had been enacted just weeks before Fukushima. As Professor Robert has pointed out, and as you've read in the briefs, it had been accompanied by a newly proclaimed energy policy of the government, which was to be valid until the year 2050. And all of this then was overturned in an instant, as my colleague Mr. Rangwald will explain, because a tragic accident in Japan changed the perception of the German public on nuclear power. You see on the screen an excerpt from the coalition agreement between the Christian Democratic Party in Germany and the Liberals after the 2009 election, where they clearly say that they are prepared to extend the operating life of Germany's nuclear power plants because they consider the bridging technology necessary to meet climate protection goals. In fact, however, the Christian Democrats had early on even opposed the atomkonsens. They had in their electoral platform for 2005 that they wanted a lifetime extension, just had not been able to implement this because of the coalition with the Social Democrats. The lifetime extension was negotiated with the operators, like the atomkonsens, for nearly a year. As the witness Dr. Portugal explained in his witness statement, those negotiations nearly failed because the operators wanted very clear, very binding, specific promises of what they would receive under lifetime extension, while the government initially said, well, if you get a lifetime extension, you have to pay, but, and I'm now reading the first sentence of section 19 of the witness statement of Dr. Portugal, Dr. Hinhofer explained that the NEPV could only be agreed upon once the OEPV would be used up. Thus, it was uncertain whether and to what extent the NEPV would be granted. And he then explains in his witness statement that this was unacceptable for the operators. That was the night from 5 to 6 September 2010, that they stood up and that they left the negotiating table basically saying, then we have no deal. And he further explains that in the middle of the night the government came back and said, okay, we can agree, we have a deal. And the deal was the development fund agreement, which was signed by the operators in November and by the government in January 2011, that the operators receive additional electricity production volumes, the so-called NEPV, and very importantly, as also mentioned by Professor Robert, that in the preamble the parties say, well, we might have different views on the legal quality of the atomkonsens, but we confirm its content and we only deviate from it insofar as it's explicitly said here. That means that the guarantees under the atomkonsens were confirmed once again by the government to be binding. And here you see an annex to the development fund agreement, which is Annex C, Part 2, and it contains a table which was to become a table to the Atomic Energy Act. And it clearly says Appendix 3, blah, blah, shall be worded as follows. And you see there are two columns. The one concerns, I'm sorry, this is strange. It moves on its own. The one concerns, the second column contains the old electricity volumes granted under the atomkonsens, and the column to the right contains the new electricity production volumes. And you'll see there's a stark difference between Brunsbüttel and Krümmel. That lies on the fact that the development fund agreement differentiates between old plants and new plants. Old plants were considered to be all those which entered into operation until the end of 1980. New plants, as you know, starting after 1981. And Krümmel was a new plant, like all the plants which are still operating, while Brunsbüttel was an old plant. And the difference results from the fact that old plants received fewer volumes than new plants. Here you see the effects if you briefly allocate the volumes granted over time. It's taken from a memorial, paragraph 186, and you see in blue the old electricity production volumes, you see the standstill times, and you see in green the additional likely operating time for using up the new electricity production volumes. It is noteworthy that in the bill, in the explanatory part of the bill which implemented then the lifetime extension, the 11th Amendment, the government confirmed that the German nuclear power plants have a high level of protection, and we ask you to bear that in mind. That was in December 2010. December 2010, while the reliability review for Krümmel was still pending, and this was a draft bill by the government, and the government had signed the agreement and had granted to Krümmel 14 years more lifetime. We say this is highly relevant because you have, during the whole of this proceeding, a stark difference between the treatment and the evaluation of the Krümmel power plant before the 13th Amendment and after the 13th Amendment. Here you have a government which says we're extending your lifetime by 14 years, and there you're now having a respondent which says, well, who knows whether the plant ever would have reconnected to the grid. Let me briefly come to the issue of the nuclear fuel tax. Germany, in the atomkonsens, you know this section already, promised not to introduce discriminatory taxes. The government nevertheless initiated the Nuclear Fuel Tax Act. As we've as we've explained in the reply, the government charged the Ministry of Finance with drafting a bill. The government, here this is an excerpt from a press conference, the federal cabinet approved the draft bill and then provided a formulation aid for its government parties and parliament, which they could bring in. The nuclear fuel tax is discriminatory. And to understand that, let me briefly explain how the system of energy taxation is in Germany. Electricity generally is taxed. That is based on the European Directive 2003/96 electricity which is produced. However, if you produce electricity by the use of hydrocarbons, oil, gas or coal, then oil, gas or coal are not taxed. If you use oil, gas or coal for other purposes than producing electricity, the use of them is taxed. So for hydrocarbon power plants, the input is taxation free and the output is taxed. For nuclear power plants, both input is taxed, the nuclear fuel, and the output, because the electricity has to be paid. And that is, despite respondents' contention to the contrary, a discrimination. The European Court of Justice has not decided otherwise. A judgment exists. We have submitted the press report from the European Court of Justice to the record, but it only concerns the compatibility with European law. And essentially, the ECJ said, well, since the directive only relates to hydrocarbon fuels and not to nuclear, this tax can't breach the directive, and therefore it's compatible. We have no EU law to the contrary. And it is perhaps noteworthy to point out that the claim that it is in breach of the atomkonsens was not made up by us for the purposes of these proceedings. Operators early on, already during the negotiations for the lifetime extension, considered it to be a breach of the atomkonsens. You'll find it in the preamble of the Development Fund Agreement. It's very clearly mentioned there that the operators reserve the right to go to court, and currently there are proceedings pending at the Federal Constitutional Court, which might end this year, might end next year. We cannot give you any specific indication about this. Mr. President, members of the tribunal, unless you have questions to what I just said, I now would like to focus on the point on which Germany has spent most of its energy and time in this case, and that is the status of KKK plant. May I proceed? Okay, thank you. I'd like to show you briefly the movie which we submitted together with the reply to the record, so you get a better impression of what the plant is like. No sound?
Vattenfall, as one of Europe's biggest heat and energy producers, operates 9 nuclear reactors in Sweden and Germany. The 2 nuclear power plants in Germany, the Krümmel and Brunsbüttel plants, are managed by Vattenfall Europe Nuclear Energy GmbH, based in Hamburg. These nuclear power plants are operated under German atomic law. They're supervised by the supervisory authority of the federal state of Schleswig-Holstein. The Krümmel plant is situated next to Geesthacht, the River Elbe, and 30 kilometers away from Hamburg. With an installed electric output of more than 1,400 megawatts, the boiling water reactor, which started operation in 1984, is one of the largest boiling water reactors worldwide. The Krümmel plant provides enough electricity for the city of Hamburg, the second largest city in Germany, inhabited by nearly 1.8 million people. Nuclear reactors have to be cooled permanently. It's therefore only possible to operate nuclear power plants near perennial rivers, lakes, or the sea. Flooding protection has to be guaranteed by all means. Due to its specific topographical position, the Krümmel plant is especially protected against floods. Measured against the height of tide of flood occurring once in 10,000 years, which was the basis for the review of all German nuclear power plants by the Reactor Safety Commission, there was no risk of flooding for the Krümmel plant. By building a flood wall and installing a mobile flood protection system, these requirements have been met. Furthermore, the waters of a flood can flow across the lower dikes on the opposite side of the nuclear power plant. The Reactor Safety Commission thus concluded that a flooding of the nuclear power plant site and a danger for the basic functions of the nuclear power plant are excluded due to topographical reasons. The Krümmel construction had to comply with the strictest safety regulations in force since 1973, which were applied to all German nuclear power plants still in operation today. The Krümmel plant was built between 1974 and 1983 and started power operation in 1984. Nuclear fission within the fuel rods takes place in the reactor pressure vessel, which is filled up to 2/3 with water. The split particles fly off to release friction heat through the gas-proof fuel rod claddings. The water surrounding the fuel rods boils under high pressure. Boiling water reactors produce steam that is directly conducted to the turbines. Therefore, not only the reactor building, but also the engine room has to be controlled permanently for radioactive activity. The controlled buildings are denoted as the control area. As in all boiling water reactors, the Cromwell plant can adapt its performance to the demand and is thus well suited for the stabilization of the grid. Nearly 120 tons of live steam per hour flows with a pressure of 69.6 atmospheres to the 64-meter-long 4-part turbo set, consisting of 1 high-pressure part and 3 low-pressure parts and 1 shaft, which is connected to the generator. Thermal energy is transformed into rotational energy. The shaft constantly turns at 1,500 rotations per minute. The voltage at the generator is 27,000 volts. The electric output of 1,402 megawatts is transferred to the 2 large generator transformers. They're situated outside the machine house and thus outside the control area, which is to be reviewed for radioactivity by radiation protection. These generator transformers are parts of conventional power plant technology. The control area, as well as the entire enclosed area of the power plant, is controlled by an object protection service around the clock to prevent possible dangers from inside and outside the power plant. German nuclear power plants are divided into different security and access areas. Therefore, there are further access controls situated at the entrances to the working areas. The nuclear power plant is monitored and controlled from a central main control room. The control system is a multi-channel system with a self-monitoring circuit technology. This is a basis of the multi-level security concept. Access from the outside through foreign computers and networks is impossible. The data produced by the monitoring systems is permanently recorded and stored in an archive. The Cromwell plant also has, directly beside the reactor building, a bunkered separated control station, ensuring the plant's safe navigation even in case of an outage of the regular control facilities. Moreover, the Cromwell plant's design provides several redundant diesel aggregates and battery backup for multiple safety systems. With a view to the expected remaining lifetime, investments in new turbine sets and a new generator were made. Further investments were made in the plant's control room with the module-based process computer and the bunkered control room. The new batteries and the new 660-volt, 380-volt switches, as well as the steam-driven pump, may serve as examples. 39 Brett-Schneider valves were also renewed. One of these valves weighs up to 4,000 kilograms. In light of their size and weight, it's not difficult to imagine why their manufacturing process regularly took 2 years, and renewals undertaken by the Cromwell plant were complex. Parts of the valves were either exchanged, or the layers affected by cracks were removed from the valve's tail, and afterwards filled up by welding with stainless steel, alloyed with molybdenum. The repair of the Brett-Schneider valves thus took time. In 2005, the power output of the power plant was increased from 1,316 megawatts to 1,402 megawatts by installing a new turbine. The high-value material of the old turbine is currently being fed into the economic cycle again. For that, the turbine is disassembled by a specially designed portal-type saws and boring mills into manageable pieces. The pieces, packed in pallet cages, are brought to decontamination via special techniques, such as high-pressure water jet, abrasive blasting, and ultrasonic sound. The pieces can only be fed into the economic cycle when they've been proven to be free of radioactivity. the disassembling of the old turbine will in all probability take 2 years. To operate the nuclear power plant, new fuel elements are needed on a regular basis. These fuel elements are stored in the dry storage of the plant. To level price fluctuation and delivery periods, the dry storage is capable of storing several hundred fuel elements. Currently, 152 new fuel elements are stored inside the dry storage. Inside of the reactor building at a height of 52 meters, the storage pool for the used fuel elements is located. In mid-2015, 1,094 irradiated used fuel elements are located in the storage pool. During the annual revision, about 1/6 of all fuel elements located in the reactor are replaced. The replacement takes place underwater for radiation protection purposes. The water covers the reactor flooding room as well as the storage pool. The fuel elements are exchanged between the reactor and the storage pool using the transport unit for fuel elements. Because the fuel elements produce decay heat, the water has a cooling purpose in addition to its radiation protection purpose. After around 5 years, the used fuel elements are moved into caster casks and transported to the interim storage facility. The nuclear interim storage facility at the Krümmel plant, in operation since 2006, provides room for up to 80 caster casks. It's constructed with 1.3 meter thick walls and a 1.5 meter thick ceiling made of massive steel reinforced concrete. The total mass of the Krümmel plant is approximately 548,000 metric tons. In case of dismantling, 10,000 tons of the total mass have to be stored in a final storage, and approximately 33,000 tons can be reintroduced into the economic cycle after certain decontamination procedures and clearance measurements have been carried out. The remaining part of the total mass is conventional waste, which can be recycled and implemented again in the economic cycle, such as in the construction of roads.
Members of the tribunal, much has been said by respondent about KKK being a construction line 69 plant. I assume I do not need to explain to you in more detail that a construction line means a design concept for nuclear power plants. And while all construction line 69 plants share some common design features, our expert Mr. Neumann will explain this to you when he will sit here. The concept was continuously developed and upgraded, and Mr. Neumann will explain to you why comparing Krümmel with the old construction line 69 plants is similarly erroneous. He will explain to you that a nuclear power plant is not a serial product, it's made to measure, conforming always with the then applicable and valid safety requirements. And it's perhaps interesting to point out that even respondent's expert, Mr. Bandholz, in his report, first report in paragraph 151, has pointed out that Krümmel has a much more extended safety design than the other construction line 69 plants had. Now, what you see on the screen is a very rough illustration of the battle of experts in this case. You see on the left side respondent's experts, on the right side our experts. Respondent has more experts because they had the last word in this case. Germany has taken great efforts to set out minuscule details of the status of KKK plants since June 2009. Their submissions and their reports have a level of detail which might even overwhelm a German administrative court. We think this is a smokescreen, nothing else, the sole purpose of which is to prevent you from seeing the whole picture. It is a clear attempt to create a procedural... Herr Buschka, wieso läuft das automatisch? to create a procedural reality which has nothing to do with the actual reality. We apologize that we also had to file expert reports in response, but we cannot let this remain uncountered. But we think you don't need this. There are on the record 7 undeniable facts which allow you to take the helicopter's view at this battle of experts and to determine what the actual reality is. Sorry?
Before you proceed, is this an appropriate moment for the break, or you have another moment in mind for the break?
I think, well, this is a new question, but I think it will take perhaps 10 or 15 more minutes at most, then it would be finished.
Okay.
I leave it, it's in your discretion.
Look where we are. Please proceed with your 10 minutes.
Okay, thanks. The first fact is KKK is safe. It's undisputed, it's on the record, it has been admitted by respondent. Respondent, it says, does not dispute that the Kremlin nuclear power plant met the requirements to be considered safe for purposes of German nuclear law. And this, of course, makes sense since they also extended the lifetime for 14 years, and you wouldn't do this for an unsafe plant. The second fact is that the reportable events about which so much has been said, which were so painstakingly detailed by respondents' experts, have little or no safety significance under the international so-called INE scale, which values and weighs reportable events. This has been perfectly described by the witness Mr. Klosters, at that time head of the supervisory authority, in a letter of February 2010. That letter was a response to a request by the county of Harburg, that lies south of Hamburg, to withdraw KKK's operating permit due to the 2009 shutdown. Mr. Klosters, in the response, wrote a letter of exquisite clarity and pointed out that the public perception of an event and its technical evaluation would be different animals. He says, I must note that the term incident is often used by the general public, as in the case from the resolution of the Harburg District Assembly, in an undifferentiated manner. He then explains the 7-step INE scale from 1 to 7 and continues to explain that it has a level 0, which signifies events of little or no safety significance. And then he confirms that, that the events subject to investigation here represent level 0 events. And he also addresses the contention that Kreml was at the top level of reportable events and says the fact that a nuclear power plant occupies the top position is not sufficient as a legal basis for revoking the operating license. And in that, he was entirely correct. The TÜV had agreed to that. The TÜV had not only reviewed in its report on the safety review each individual event, they had gone forward and also looked whether there was a tendency, a repetition of certain events, anything of safety significance. And the statements are also of explicit clarity. They say, the evaluation of the systematic errors does not provide any evidence for general safety relevant deficiencies in the plant layout or its management. They even say, well, our analysis reveals no clear reason why the frequency of incidents is above the average. They reviewed it, they said, well, we don't know, but it's no problem. The third fact is that politicians were not interested in this truth. You see on the screen an excerpt from an article in the weekly Der Spiegel, which is far from being nuclear friendly, which discusses the first shutdown in 2007. And you see the quotes for the Federal Minister for the Environment, Sigmar Gabriel. The breakdown was the apparent welcome proof that nuclear power was a high-risk technology which needed to be done away as soon as possible. And later on, that article says the 2 SPD ministers used the information about the aberrations, that means the incidents, which were of little significance in terms of safety, correct, to attack the entire nuclear industry. Gabriel called Kreml a hazardous reactor and stated mockingly, that German nuclear plants are the safest in the world, they just crack and burn occasionally. And that is in complete contrast to the evaluations of the incidents. It completely ignores, for example, that the transformer outside the building burned and not the reactor. Krümmel became a politicized power plant in the midst of the negotiation about the lifetime extension. The fourth fact, members of the tribunal, is it's undisputed that as of March 2011, everyone assumed Krümmel would have restarted by the end of 2011. What you see there is Exhibit C 1999. It is a response by the supervisory authority to the Federal Grid Agency after the shutdown. The Federal Grid Agency was concerned that one might need a power plant as a reserve power plant, wrote to the supervisory authorities and also to Schleswig-Holstein and said, is a restart of power operations even in the realm of possible? And the answer is clear. The plant has been technically ready to restart, to start operating since spring of 2011, and they say the restart date resulting from these measures was scheduled for the end of 2011. The fifth fact is that all restart relevant measures had been concluded. There is another very important document, Exhibit C 200. It is a response, again, from the supervisory authority to the Federal Ministry of the Environment. After claimants had submitted their request for arbitration and sent a copy to Germany, at the same day the Federal Ministry of the Environment sent a request to Schleswig-Holstein and said, well, please inform us. It says, then you asked for a presentation of the facts relating to the technical and administrative preconditions for restarting the Krümmel nuclear power plant in March 2011. Well, we don't know why they asked for March 2011, because we never said the plant would restart in March 2011. The contention is, our position is January 2012. But once again, the answer was very clear and very explicit. They listed 6 points which they considered to be restart relevant. The first 4 contain technical measures, and in that letter they go through that letter, those measures one by one, and each time they say the necessary works have been concluded. And this includes the issue of the fuel repair measures. You will recall that one of the aspects about which respondents' experts get so terribly excited is the fuel element repair works. That there were foreign elements in the reactor building, that fuel elements had to be taken out, you had to insert screens and filters, you had to clean them, and you have full expert opinions which say, well, this needed the consent of the authority, and pages over pages of details, and you have this letter which says cleaning, inspection, installation of filters in the base of the fuel rods, and the installation of screens were completed, and additional administrative measures were stipulated in instruction. From the point of view of the Nuclear Supervisory Authority, the procedure was concluded by the reference date you've specified in order to comply with the necessary damage prevention for the 22nd generation cycle. That is nuclear language speak. In plain terms, they say all the works have been undertaken, we have no objections, all that needed to be done has been done. There are 2 aspects which were outstanding. Firstly, there was no restart application, and also claimants expert Mr. Grötzinger and Professor Ewer put great emphasis on this and say, oh, well, look, no restart application has ever been submitted. Well, members of the tribunal, that is misleading, because you do not submit a restart application 9 months before. Fukushima was in March. The plan was to restart in January 2012. You do not submit a restart application 9 months before. In June, the German parliament had passed the 13th Amendment of the Bundestag. It was clear Krümmel would never restart. You do not file a restart application 6 months before restart, and you do not do it if it's clear your plant will never be allowed to restart. We have it in the evidence. Exhibit C70 is the restart permit from 2009. The application was filed 3 days before. Their contention makes no sense. Then the 6th fact is the issue of reliability. Germany and its experts place a great emphasis on reliability and say that it would be a cornerstone of nuclear law. That is basically correct, but ripped out of context. The important thing is that reliability is an issue for granting an operating permit. You see on the screen an excerpt from paragraphs from Section 7 of the Atomic Energy Act, which lists the preconditions for issuing a permit. And one of the preconditions is there are no known facts giving rights to doubts as to the reliability of the applicant. The point is, this is a legal term. It's embodied in a law, and if you do a reliability review, whether there are doubts to the reliability of the applicant or not is the outcome of a reliability review. It is a legal finding, which is the outcome of an administrative review. No such review, no such outcome has ever been made. Once you have an operating license, you are reliable under law. The authority might initiate a review, it might see certain facts, and it might wonder whether these facts are sufficient to give rise to doubts. But as long as a reliability review is not concluded, there are under law no facts giving rise to doubts. The review must be completed, there must be a decision which one can be appealed. That has never happened. You can compare it, if you wish, with a nice sentence, innocent until proven guilty. In this case, criminal was explicitly acquitted in 2013. The reliability was confirmed. There never were facts giving rise to doubt in the sense of the law, and that is, our experts will, Professor Arndt will explain that, why there could never be why the reliability review could not prevent the restart. The seventh and final fact is that Germany knew all of this, and that it knew that it thus needed to change the law in order to shut down criminal. You see on the screen a memo from the Schleswig-Holstein State Chancellery shortly after Fukushima, where they discuss the plans for moratorium, where they explicitly say, basing such an intrusive measure, such as shutting down operations pursuant to Section 19, based on a new safety policy, and then they say, which is now politically desired, is of doubtful legality. It is on the record that Schleswig-Holstein wanted to shut down the plants. At the latest, after Fukushima, that was clear. You see a quote from Prime Minister Carstensen who says, "No, I don't want to switch them back on. I say, and my aim is not to switch them back on," and then he says, "but I have no legal options whatsoever to order this." Germany thus knew that they needed to change the law. This is another memo from the Schleswig-Holstein State Chancellery. My colleague Mr. Rangewald will deal with it in more detail, where it is concluded that with directives by administrative authorities, for example nuclear supervisory authorities, it will not be possible to fulfill the political objective of shutting down the nuclear power plants at Brunsbüttel and Krümmel permanently. Members of the tribunal, this is the essence of the battle about the Krümmel power plant. The fictive reality which Germany and its experts try to create has nothing to do with the actual reality. The alleged problems which respondents' experts raise were not considered restart relevant or not even mentioned by the authority. The plant was safe and would have restarted in 2011. Germany never created the reality it now conjures up in these proceedings. You see on the screen a quote from Chancellor Dr. Merkel in a TV interview when she was asked about whether it wouldn't be a good idea to shut down the so-called old nuclear power plants and also Krümmel permanently. And she says there, "These reactors have continued to operate since the decision by the red-green government to exit nuclear energy. And if there had been any indication that they are not safe today, then they would not be permitted to operate for one single day longer." They couldn't shut down Krümmel, not under law. They needed to change the law for that. Krümmel was safe, Krümmel would have restarted, and Krümmel had been already before Fukushima a playball of politics. That is why we think it's much safer for you to rely on ex-ante evaluations by the supervisory authority than on ex-post justifications by respondent experts. With that, members of the tribunal, I conclude this part of our opening statement. And unless you have further questions after the break, my colleague Mr. Rönnwald would continue. Thank you very much.
Should now take a break for 20 minutes. Sharp. Adjourn.